Good morning and welcome to this Evershed Sutherland PROPcast. I'm Anna Woodford, professional support lawyer to the real estate practice here at Evershed Sutherland. Some housekeeping before we start. This morning's session will last for half an hour and we commit to sticking to time. You're very welcome to use the Q&A function to raise questions as we go, but please give your name so that we can come back to you after the session if we don't have time to address the question during it. Also, just to note that the session will be recorded and made available via our website and as a podcast, available through Apple or Spotify. Our subject today is Martin's Law. I'm joined this morning by Sarah Valentine, who is a partner in our health and safety practice, and Claire Watson, an associate also from our health and safety practice. So Sarah, could you please start us off by giving us some background on what Martin's Law is?
Of course, Anna. So on the 3rd of April this year, the Terrorism Protection of Premises Act came into force. And this is known as Martin's Law, and it pays tribute to Martin Hett, who was sadly killed along with 21 others in the Manchester Arena attacks in 2017. Now, his mother, Figa Murray, has campaigned tirelessly for the government to change its approach on how venues manage the risk of terrorist attacks. Now, Martin's Law really is enhancing security measures at public venues with a view to preventing terrorist attacks. The Manchester Arena inquiry was a statutory public inquiry that found that communication, coordination, and cooperation was absolutely key in making sure that venues and premises really enhance their counter-terrorism measures. It's not about preventing terrorism attacks from happening, but it's about ensuring that premises within the UK are prepared and protected against these attacks and therefore reducing the impact. The aim is to keep people safe in the event of an attack. There are some requirements on larger premises and events, which Claire will take us through shortly, where those venues and premises can put measures in place to reduce the vulnerability around counter-terrorism attacks. And this all feeds into really the government strategy on contest, which is their overarching strategy around managing terrorism across the UK.
Thank you. So Claire, who does Martin's Law apply to?
So the Act applies to certain premises and events that are entirely or partially open to the public. And if we look firstly at the definition of premises, so to fall within the scope of the Act, premises must satisfy 4 criteria. The first of that criteria is that there must be at least one building on the premises, and that could also be land around a building. So, for example, it could be a pub, including the pub garden, or premises which are primarily outdoors, but there is one or more buildings on site. The second criteria is that premises are wholly or mainly used for one or more of the uses that the Act specifies, and that includes a wide range of locations. It could be a shop, a restaurant, a bar, a sports ground, a hotel, a place of worship, a hospital, or educational institutions, as well as venues hosting entertainment and leisure activities. There are some exceptions to that, which I won't go through now, but just to be aware of. Thirdly, that the premises must meet the thresholds for individuals present at the premises. And venues are categorised into a standard duty and enhanced duty based on capacity. If we look at those capacity thresholds, so the standard tier applies to premises where it is reasonable to expect 200 or more individuals to be present from time to time. And the enhanced tier encompasses premises where it may reasonably expected that 800 or more individuals will be present from time to time in connection with one or more uses that are specified in the Act. And there are some uses where only the standard duty would apply regardless of capacity, and that's places such as places of worship and buildings used for primary, secondary, or further education. And finally, the fourth criteria is to look at whether the premises are excluded premises. And those are, for instance, Parliament, open air premises used for recreation, if it's open access, and transport premises that are already subject to relevant existing legislation to consider and mitigate threats. Moving on to the criteria for the qualifying events under the Act. So again, that criteria is that the event must take place at premises caught within the definition of the Act, and that must take place in a building, on land, or at premises that consist of a combination of the two. So qualifying events can take place on premises that are not qualifying premises under the Act. And there may be qualifying events, for instance, festivals that don't have a building on site within the perimeter. The second criteria for the qualifying events is that they must host at least 800 attendees at the same time. And the third is that there are specific entry conditions. So are there measures in place to check that attendees satisfy a condition of entry? So it could be to enter the event that the members of the public have paid, or that they have a ticket or a pass, or are members of a guest or a club, association or other similar body. And it does also encompass free events. So somebody doesn't necessarily have to pay to go to the event if there's a specific check on entry. So for instance, it could be, do they have to register to attend? And finally, the fourth criteria is to be accessible to members of the public. So an event's not in scope if individuals are attending in a personal or private capacity. So for instance, if we look at debates during the amendments to the bill, for instance, the Home Office Minister Dan Jarvis highlighted that the amendments clarified that the intention that premises and events are not in scope where attendance is in a personal or private capacity, and he gave the example of a wedding attended by relations or friends, or an office party attended by employees and customers. Now, again, there are some excluded events held at certain premises, such as where the premise is used for worship, childcare, or primary, secondary, or further education, that it's worth being aware of and just looking at.
Thanks, Claire. So who's responsible, Sarah, for ensuring compliance with this legislation?
Yeah, thanks, Anna. So I can probably break this into two aspects. Where an individual is in control of the premises, it's usually the premises operator. They will be classed as a responsible person. And also an individual who is managing an event, a qualifying event at one of these premises, they would also be classed as a responsible person. And it's their responsibility to ensure that the requirements of the Act are met, and they can't delegate that responsibility to somebody else. So if they hire the venue out to somebody else, another company to assist with part of running that event, they can't delegate their responsibilities under Martin's law. When we look at it as in terms of a company who's managing a qualifying event or a premises, then that individual who is responsible is called the designated senior individual, and that's somebody with suitable seniority to coordinate and manage that event and ensure legal compliance with the requirements under Martin's law.
But how does that all work if you've got a sort of a multi-let building where you've got perhaps a number of different tenants in one building? How does it get separated out between the different tenants, and what role does the landlord play in all that as well?
That's a good point, probably one of importance to the audience listening today. And really, in that scenario, multiple people can be responsible depending on what is taking place and depending on how they operate their premises. And there really is going to be a need for transparency, communication, coordination, and cooperation when we're looking at how Martin's law and the requirements under the Act are being managed. Typically, I'm trying to give a scenario at a shopping centre, a landlord would in some instances be classed as a responsible person or the designated senior individual there if there was large capacity numbers coming in, and they would have overall responsibility over those communal areas. Also, though, the shops, those individual units within that premises, would also have their own responsibilities depending on if they were running any sort of qualified events and again the numbers that were coming through. What's really important is there is that coordination, because what you don't want to do is one of these, whether it's a responsible person of a retail unit or whether it is the landlord of the shopping centre, have measures in place to adhere to Martin's law requirements that may undermine another user. So it's really key that there is communication discussion about the risks at those premises so everybody can manage, the requirements under Martin's law for their undertaking properly.
I think what you're saying is if you've got a lease, because you said earlier that it's not possible to delegate the authority. Now, sometimes in leases, landlords will delegate obligations to tenants, but I think on this one, that's not possible. So the lease might say that, but actually everyone's got to keep talking and communicating. Is that right?
Precisely. You can't delegate the responsibilities, and everybody should have, regard to Martin's law and the requirements that impact their business and their undertaking.
Thank you. So, Claire, on a practical level, what do people actually need to do to make sure they're compliant with Martin's law?
Thanks, Anna. So, in our view, some of the key purposes of Martin's Law is to ensure that there's an effective security plan in place that enables those responsible for premises or events to look after us if we're attending, know what to do in the event of an emergency, and to mitigate risk. So, it's important to note as well that doesn't necessarily involve a lot of work or expense. It's about understanding the vulnerability and risk so that in the event of an incident, informed decisions can be made to implement procedures. And I'll go through those procedures set out in the Act in a moment, such as the evacuation and lockdown. So if we're looking at the standard duty premises, those responsible for standard duty premises are required to have in place, so far as is reasonably practicable, appropriate public protection procedures. Now, you may be familiar with that term, reasonably practicable, because it is a concept that we do find in other regimes, such as health and safety. And it takes into account your particular circumstances, including the nature of the premises and the resources available to you. There are procedures that may be expected to reduce the risk of physical harm to individuals if an act of terrorism occurred at the premises or in the immediate vicinity. And set out in the Act as well, there are procedures to be followed by people working at the premises where they suspect an act of terrorism is occurring or is about to occur at the premises or in the immediate vicinity. So, turning to the Act, what are those procedures? There are 4 procedures set out. The first of that is evacuation. So, how to get everyone out safely the premises. So, what are the escape routes and where would people go to? The second is evacuation, and that's the process of bringing people safely into or to safer parts of the premises. So, for example, if it's a shop, it might be that you bring people into a storage room at the back of the premises that has secure windows and a lock on the door. The third procedure is lockdown, so securing the premises to prevent individuals entering or leaving the premises. So, examples again, that might be including locking doors, closing shutters, using barriers that are available, closing windows, turning off the lights. And the fourth procedure is communication, and that's the process of alerting people on the premises to the danger. So, if you do have to invoke the evacuation or lockdown, how are you telling people that what to do? How are you giving them instructions? It might be that prior to the event, you've done training and circulated procedures to staff. And if we look at the government's fact sheet, that lists the types of procedures, and it states that the requirements for these smaller premises are focused on activities to enact policies and procedures that are expected to be simple and low cost. The aim of the requirements is to improve staff preparedness and responses, and the Act does not require physical alteration to the premises or the purchase of equipment for the purposes of having those procedures in place. If we move on to what you're required for enhanced duty premises and qualifying events. So in addition to the public protection procedures that I've mentioned for the standard duty premises, those responsible for enhanced duty premises and qualifying events are required to go further and have in place, so far as is reasonably practicable, appropriate public protection measures. So, where the public protection procedures focus on enacting policies and procedures, the measures focus on furthering those objectives of reducing the vulnerability of the premises or event to acts of terrorism, or reducing the risk of physical harm to individuals. Going through those measures, so they include measures that might be in relation to monitoring the premises or event and their immediate vicinity. So, examples might include CCTV, doing walkarounds, the event, having the radio systems in place for the communication, controlling the movement of individuals into, out of, or within the premises. So that might be crowd barriers, it might be ticket checks, might be having door staff in place. The third measure is physical safety and security of the premises. So are there any standoff zones? Do you require hostile vehicle mitigations in place, increased lighting, areas for bag storage? And the final measure is the security of information. So, what is appropriate to share and with who? So, as an example of that, you might have floor plans, and they may be able to be seen to assist in the event of planning an act of terrorism. And so, who should those be shared with? Are they being held securely? And the specific measures will vary depending on the qualifying events and the premises. I think as well, just to note the training. So, whilst for standard Ts there's no specific requirement for specific training, workers should be sufficiently instructed or trained on the procedural measures and procedures to carry them out effectively. So, when you're considering training, Are you looking at the induction training, the employment manuals that you have in place, the signs that are around the premises? Are there specific training prior to events? So you could do sort of tabletop activities and walkthrough scenarios. Just looking at what to do to comply and what we're seeing organisations are doing now. So the type of things that we are seeing clients ask us for their assistance on to date includes looking at checklists for events, risk assessments, and their frameworks as well of policies and documents and protocols for the premises or event.
Thanks, Claire. Sarah, you talked about how there's a split between standard tier premises and
Mhm.
enhanced tier, and this depends on the number of people that are likely to be present. But how do you work that out? What criteria do you need to use?
Yeah, it's a good question. So, the responsible person or the designated senior individual need to have regard to the numbers that are coming through in order to work out whether, like you said, it's standard or enhanced tier obligations they need to comply with. And I think the best way to look at those kind of capacity thresholds is either to consider historic data, so looking at your previous qualifying events, what types of numbers you've been hosting events for, or just footfall if it's a shopping centre, etc. If it's some sort of event, if there's any tickets or registration sign-ins, how many of those have been logged beforehand? And also, what's quite helpful as well is looking at fire risk assessments or building regulations, building safety regulation documentation, because often the management of crowds in those types of incidents, evacuations have been calculated as well.
Thank you. And Claire, is there any additional guidance available to help people navigate the requirements?
Yes, there is guidance available currently, and we are waiting on further guidance from the Security Industry Authority. But fact sheets are available on the government website if you search for the Terrorism Protection of Premises Act 2025 fact sheets. And there's also free technical guidance and operational guidance advice on protective security on the National Protective Security Authority and Protect UK websites. Um, and there are other companies and organisations that produce guidance that might prove to be useful. But just to remember as well that the SIA doesn't endorse any third-party products or providers that claim to ensure a premises or location can comply with Martin's Law. So there is guidance available, and we're expecting further guidance to come out.
Okay. And when are these requirements coming into force, Sarah?
Yeah, I touched on at the beginning that the Act came in on the 3rd of April this year, but the UK government's allowed probably about 24 months for implementation. So allowing operators and premises owners to take the time to look at the guidance and follow what the SII guidance, so that's the Security Industry Authority, who are going to be the regulator of this, um, to allow them time to plot through and see what they need to do to their existing systems to enhance it to meet these additional obligations.
So the idea being that although it's not enforced now, actually people can't afford to wait until it is enforced.
Oh,
The
no,
times for
no.
planning.
Yeah, definitely, definitely, because people will be thinking about their events calendars in the forthcoming 12 months, etc. And really, a lot of this feeds into existing security arrangements, risk assessments, etc. So it's things that organisations can be looking at now when they come to review and reflect on existing risk management strategies.
Hmm. So Claire, who's going to be responsible for enforcing the Act?
So the Act's going to be regulated by the SIA, who we've mentioned already, the Security Industry Authority. And they are an executive non-departmental public body sponsored by the Home Office. And they were established to contribute to public protection by setting and approving standards in the regulated private security industry. And overseeing compliance with Martin's Law is going to be a new function of the SIA. Just looking at the types of powers that the SIA will have, they'll be granted investigatory powers to access premises and events, to conduct inspections, execute warrants, and issue notices to require information to assess compliance.
Thank you. Sarah, you and Claire have given us a really helpful technical walkthrough of the requirements of the Act, but could you perhaps give us some practical examples to help people see what all this will mean to them in practice?
Yeah, and I think probably what the best thing I can do is give about 6 scenarios of where organisations may be in or out of the legislative framework. So let's start with, we're about to embark on graduation season. We get a lot of questions around whether graduations are a qualifying event, and that will depend on numbers, but there is a possibility that they will fall within the requirements of the Act. So there will need to be enhanced security measures, risk assessments, etc. The next thing will be factories and shops. So what's relevant there? So if you've got a factory that's got, say, for instance, a factory shop on the side, the factory is part of a private workspace, so wouldn't be classed, but that factory shop in essence would be classed because it's a public venue and people can attend. Office is generally not, again, covered, but if you have an office open day for family and friends or a big client event, then that could trigger a qualifying event and you could be captured by the requirements. A festival, again, will depend on the number of people we're looking at, capacity levels, but it's likely that it could be a qualifying event. So additional security measures may need to be put into place, and it would need to look at, what are the public access arrangements maybe into play in relation to a venue. Shopping centres, I've really touched on that already, and yes, there is premises upon premises in there, and so there will likely be a duty to retail units and also the landlord, depending again on capacity numbers and perhaps whether any qualifying events may be taking place that they need to have regard to. Again, coordination, cooperation is really key, as well as communication. And then finally, weddings. Now, not necessarily for the people hosting the event, so the couple or the family, but the hotel will probably have their own requirements in terms of qualifying events, again, depending on the capacity levels for hosting those types of kind of private ceremony occasions on their premises.
Okay, thank you. And just thinking about premises that are in the vicinity of other premises. Now, we've talked about landlord and tenants having to talk to each other and talk to the other tenants in the building, but presumably it doesn't stop at the edge of the building. You need to potentially talk to your neighbours, even if they're not tenants of the same landlord. It's completely separate premises next door. But if there's a knock-on impact, perhaps you have to chat to your neighbours and plan with them as well.
Yes, yeah, that's what the guidance is looking towards, and that's really some of the determinations that came out of the Manchester Arena public inquiry. Was that kind of communication with others operating in a nearby area, impacts by infrastructure, etc. So everybody kind of communicating and coordinating that approach in terms of managing these types of terrorism risks. Um, to be fair, when you're in like a multi-occupancy arrangement, you still have to communicate in terms of risk, in terms of security and access, etc., with each other because you share those communal areas. So it really is just kind of an enhancement of those discussions and that cooperation and coordination.
Well, thank you. That's been a very interesting overview of Martin's Law. And that brings us to the end of this Evershed Sutherland PROPcast. Thank you, everybody, for listening.